Good evening. This is CrashTalk. I'm Mike Harber, your host, and it's been a while. And I apologize. We tried to do this every week, and we just got really, really busy. There's only so many hours in the day. But I wanted to come and I wanted to share about diminished value tonight, because the last thing I want is for one day for you to say, I really wish I had collected for that loss, for the loss in value that was caused by somebody else that ran into me and caused a lot of grief. And hopefully you weren't personally injured, but your car was broken and it wasn't your fault. You were sitting there at a light making a turn, and all of a sudden you saw it coming. Bam! Now what? Well, you can put your own name on it. Was it a drunk? Was it somebody texting? Distracted driver? It really doesn't make any difference. You now have a part-time job. Yeah, you do. And I got that from one of my clients who told me, he said, I feel like I got a part-time job. He said, there's so much, I have to go and I have to get estimates. I have to have my car repaired. I've got to go get a rental car. Who's taking care of you while you're doing all that and compensating you for your time and effort while you have this part-time job? Well, one part of your claim is your property damage. And your property damage consists of several things: the repair to your vehicle back to the condition it was prior to the accident, loss of use. What is your vehicle worth on a daily basis while you don't have it? You can collect that in money. You don't have to have a rental car. If you have something else to drive, or if you're just staying home during the pandemic, you can collect for that in cash. It's an element of your loss. And the other thing is diminished value. And diminished value has kind of become a buzzword. And that's what I really want to talk about tonight, because there's, I think, an awful lot of people that think, well, it's free money. I don't know if it's real. So let's start with an explanation of what does the law say. And before we go any farther, let me give my disclaimer. I am not an attorney. I'm not going to give you legal advice. If you need legal advice, you need to get that from a practicing attorney in your area. And we have many attorneys and law firms that we work with. We can certainly give you a referral. But let's consider what is your right, and getting back to where you were before this whole mess started by the drunk driver or the distracted driver that ran into you when you were minding your own business. What does the law say? Well, there's several Supreme Court decisions, but the most recent is a decision in a case called Moeller versus Farmers. And even though that case had to do with what's called a first party claim, it was a contract that David Moeller, had with his insurance company, Farmers Insurance. And he made a claim for the loss in value. And it took about 14 years for this thing to go through the courts, the fighting back and forth between the insurance company and the attorneys, Mr. Moeller. But finally, we got a decision that defines diminished value. And I don't want to get it incorrect, so I'm going to read it to you. I've pulled it up here, and it says, a vehicle suffers diminished value when it sustains physical damage in an accident. But due to the nature of the damage, it cannot be fully restored to its pre-loss condition. Weakened metal that cannot be repaired is one such example. In contrast, stigma damages occur when the vehicle has been fully restored to its pre-loss condition, but it carries an intangible taint due to its having been involved in an accident. So we're not talking about stigma damage. That's just the perception because it's been in an accident. But there are certain situations where there may not be actual diminished value. It's only that perception. For example, if you have a pickup truck and you have a chrome bumper, and that chrome bumper is damaged in the accident, and it's replaced with a new original equipment bumper, or a taillight, or a headlamp, and they're replaced with original equipment parts. It's a bolt-on, bolt-on off part. There's no paint work. There really isn't any diminished value. There could be a stigma. We're not going to discuss that. What I want to talk about is the definition that a vehicle cannot be fully restored to its pre-loss condition. And that's what happens when a vehicle has to have either Bondo, filler, paint work, welded in parts, any of those type of things cannot be put back to the same condition that it came out of the factory. It's not restored to its pre-loss condition. Now, what happens, you now have damaged goods. It isn't the same before you got hit by the drunk. So what does that mean? Well, that means that you have damages, you have a loss, your favorite car is now damaged goods. And stop and think about this. If you were out looking for a vehicle today, tonight, tomorrow, and there were two vehicles side by side that were the same year, same make, model, let's even say the same color, same condition, everything about it. They didn't a used car. But they said, oh, but this one had $5,000, $6,000, $10,000 worth of damage. It had been in a collision. But, oh, it was repaired. Oh, it's back to the way it was. Would you be willing to pay the same amount of money for both of those vehicles? I think not. I think not. So, how do you determine that? There are several ways. And let's stop and think about who's paying for that. Who's going to pay you for the damage that's remaining to your vehicle? It's actually the person that caused the damage. And they have insurance to keep them or to cover damages they caused to somebody else. It's the liability portion of a policy, which our state requires everybody that's driving is supposed to have the minimum limit of liability coverage so that if they damage your car or you, that they've got insurance to pay for that. Otherwise, you would have to sue that person, not their insurance company, but that person. So you have an accident. Your car is damaged. You have it repaired. And now you're considering, should you collect for the remaining damage on your car because it's now damaged goods? You would seek an expert, somebody that's qualified to make the determination. But then it's your duty, it's your job to pursue that loss. I've given this example before. You go to the grocery store and you put a couple gallons of milk and eggs and whatever lunch meat in your cart. You go up to the checkout, you pay for everything, and you're placing them back in your cart so you can go out to your car, and the checkout lady person reaches over and they grab one of the gallons of milk. And they say, well, we're going to keep this one. And I said, well, wait a second. I just paid for that. Well, but we think we would like to keep it. What are you going to do? Are you just going to say, oh, okay. I have 2 dozen eggs. You want one of the dozen eggs too? No. Are you kidding me? Now let's stop and think about an insurance claim. When somebody has damaged your car and you take it in It's your choice where you have repairs done. Whole different episode. We need to talk about that, because you need to make sure you're finding a shop that's working for you and not the insurance company, saving them money. So you picked a shop and you have the repairs completed on your vehicle. Well, what if they say, well, we're only going to pay for this amount or that amount? They just took away one of the gallons of milk. What about your diminished value? Let's say you get your car repaired and you're happy and it looks good and you had a good experience, except it ate up a lot of your time, the part-time job, but you got it handled. Well, now you want to collect. And the person that's responsible, they've got insurance. Now, do you think they're willingly going to say, oh yeah, here, we're going to write you a check? No. I also refer to them as the playground bully. And they're going to try to push you around. They're going to try to tell you you're not entitled. It doesn't exist. We paid for the repair of your vehicle. That's all we owe. Believe me, I've heard all the excuses. Remember, I just read to you the definition in a Supreme Court decision. Your vehicle has remaining damage. That loss, that remaining damage is collectible. That's part of your claim. No different than the damage to your door, the replacement of your hood, tires, wheels, anything else that was wrong. This is part of the damage. So, are you going to let them take your lunch money? Are you going to stand up for yourself? It's up to you. You don't have to pursue it, but it is your right. And that's what we offer to our clients. Not only do we make the determination on how much a vehicle's gone down in value, but we're there to give you support. We're there to help you get your lunch money back, because it's yours. You don't want to just say, oh, well. And that's why when I started this evening, I don't want someday for you to say, our life would have been better if we had followed through and collected for the damage that was caused and our loss to our vehicle. So don't give up. You either assert your rights or you lose your rights. Understand it is your right to collect for all of your loss, and don't let the playground bully take your lunch money. It's been a pleasure. I hope you got something out of this. If you did, subscribe. Press the button down there. Hey, I'm technically challenged, as a lot of people know. So however that works, I guess you give it a thumbs up. Subscribe. Send us comments. We've got a Facebook page. We've got a website. A lot of different ways that you can be in contact with us. We're here to answer your questions. So with that, it sounds like we're getting to the point where maybe we can take our mask off. Still have to be careful. Get your vaccination. I think it's pretty simple. Anyway, you have a good night. Thank you for listening. We'll see you same time, same place. This has been Crash Talk.